Welcome and thank you for joining part 2 of SciFarth's micro-webinar series, Workforce Realignment and Reductions in Force. This installment of the series will focus on separation agreements in light of McLaren. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Chris Kelleher. Chris, you may begin.
Thank you, Brooke. Good afternoon, everybody. My name is Chris Kelleher. Today I'll be presenting with Molly Mooney. Molly and I are both associates at SciFarth Shaw in the Labor and Employment Group in Boston. Today we'll be talking about separation agreements in light of the NLRB's McLaren-McComb decision. So as Brooke mentioned, this is part 2 of a 4-part micro-webinar series that we've been putting on since August. In part 1, we discussed reductions in force more generally and workforce realignments. On September 27th, we'll be discussing WARN Act issues surrounding reductions in force. And on October 18th, we'll be presenting on using AI and technology in association with reductions in force. So we welcome you to join us for those presentations as well. Today's agenda, as I mentioned, we'll be discussing the NLRB's decision in the McLaren-McComb case and how it might impact employers and their considerations with respect to reductions in force, realignments. Specifically, we'll provide an overview of the McLaren decision and the NLRB General Counsel's memo regarding the scope of McLaren. Molly will handle that piece. Then I'll take over and provide a discussion on the practical implications and takeaways from McLaren for employers to consider who are considering reductions in force. And then we'll talk a little bit about the potential impact of continued use of broad confidentiality and non-disparagement provisions. So with that, I'll turn over to Molly to provide an overview of the McLaren decision.
Thanks so much, Chris. Hi, everybody. Thank you so much for joining us today. I'm Molly, as Chris said, and I'm going to kick off our presentation by giving a general overview of the NLRB's decision in McLaren-McComb, which is why we're here today. So the McLaren-McComb decision came out earlier this year in February. McLaren-McComb is a hospital located in Michigan, and at the time it had about 2,300 employees, and of those employees, 350 of them were in a bargaining unit. Now, during COVID, the hospital was forced to streamline some of the services and medical services that it was offering, and as a part of that, it furloughed 11 bargaining unit employees, and then shortly after furloughing them, it terminated those employees. Now, again, those were bargaining unit employees, and in conjunction with their separation, the hospital offered them severance agreements, and each of those agreements had different severance amounts for each employee, and they all signed the severance agreement at the time. Now, the hospital did not involve the bargaining unit, the union, in any of those conversations with the employees, so that was their first mistake. But we're talking about this decision today because at issue in the case was whether the confidentiality and non-disparagement provisions restricted the employee's Section 7 rights under the NLRA, and the board found that they did. Now, again, there were other issues in that case that we're not going to talk about today, but we're going to focus on the confidentiality and non-disparagement provisions at issue in the decision. So if we can go to the next slide, we're actually going to take a look at the provisions at issue in these severance agreements. So remember, there were 11 severance agreements offered to these employees, and each of them had these same provisions. So on the slide, you can see the confidentiality provision at issue in the case, and it's pretty broad. It says the employee acknowledges that the terms of this agreement are confidential and agrees not to disclose them to any third person other than spouse or as necessary to professional advisors for the purposes of obtaining legal counsel or tax advice. So what that means is that these employees, by executing this severance agreement, could not share the terms of the agreement with anyone other than their spouse or their accountant or lawyer for tax or legal reasons. So there's no exception for them to discuss the terms of the agreement with even their bargaining unit. So now going to the next slide, we're going to take a look at the non-disparagement provision in the McLaren-McComb case. Okay, so this is the full non-disparagement provision that was in each of the severance agreements. And if you look starting around halfway through on the slide, it says, at all times hereafter, the employee agrees not to make statements to employer's employees or to the general public, which could disparage or harm the image of the employer. So again, pretty broad. This provision is prohibiting the employees from making any statements to pretty much anybody, because it includes general public, that could in any way harm or disparage the hospital. So you might be looking at these two provisions and be thinking, oh, wow, I've seen these broad provisions before, or we even use those types of provisions in our separation agreements. And that's okay. There's no need to freak out just yet, but we're going to talk about what the board found to be problematic with those provisions. And then Chris is going to talk about some considerations when including these types of provisions in your separation or severance agreements. So let's go to the next slide. So what exactly did the board find was wrong with these provisions? Well, it found that they violated the employees' exercise of their Section 7 rights. Now, for some of you, you may not be as familiar with the National Labor Relations Act. So just to give a little background, Section 7 of the NLRA guarantees employees the right to self-organization, to join and form unions, to collectively bargain with their union, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And it's really that last part that was at issue in the McLaren-McComb decision. Now, one other background piece is Section 8, of the NLRA prohibits employers from interfering or coercing employees in any way in the exercise of their Section 7 rights. So essentially, employees have these Section 7 rights that the NLRA protects, and the board found in McLaren-McComb that these two provisions were overly broad and impacted the employee's ability to exercise their Section 7 rights. Now, in the McLaren-McComb decision, the board reiterated just how broad Section 7 rights are and included the fact that it extends beyond the employment relationship. So Section 7 rights aren't just limited to discussions with coworkers, but the board reiterated that it includes conversations with former employees as well. So if you look at the slide, we've included here a quote from the decision where the board says that Section 7 activity includes efforts to improve terms and conditions of employment through channels outside of the employment relationship. So things like administrative and judicial forums, and even the media, like newspapers, social media, and communications to the public. Essentially, the board was worried that employees that would have information about an unfair labor practice might feel coerced into not reporting that or not participating in a board investigation of an unfair labor practice. And one point to make here before we move on is you may be thinking, does this apply to my workforce? And the answer is it may. So it doesn't matter whether you have bargaining units within your workforce or not. Employees have Section 7 rights, but there are exceptions to that. And one of the exceptions is managers and most supervisors are not protected by Section 7, so they don't have those same rights. And not to get too in the weeds, but the NLRA has sort of a detailed test to determine whether an employee is considered a supervisor or not. And generally, the board is inclined to find that someone is not a supervisor. That way they have Section 7 rights and are protected under the Act. But it's 12 different things, and if the employee does one of those things, then they would be considered a supervisor. And it's things that you would typically expect supervisors to do, like hiring employees, transferring employees, terminating employees, disciplining employees. So to the extent you have questions about that, we can just put them in the chat and we can answer them after the presentation. So moving on to the next slide. So the board had specific reasons for why it found both of these provisions to be overly broad and violating the NLRA. Now, first, all of these reasons really relate to the board's primary concern, which was making sure that employees felt that they could report unfair labor practices to the board and participate in board investigations. That was ultimately what was the driving force behind this decision. So when the board considered the confidentiality provision, again, it said it was very broad. It prohibited employees from disclosing the terms of the agreement to any third party, which the board interpreted as including the NLRB itself. And then second, it prohibited employees from discussing the terms of the severance agreement with other former coworkers who might be deciding whether to accept a severance agreement as well. Finally, it found that the confidentiality provision also prohibited employees from discussing the terms of the severance agreements with the union. Like we mentioned earlier, the confidentiality provision did not have a carve-out for the union. It only had the exceptions for spouse and legal and tax advisors. And for the same reasons, the board found that the non-disparagement provision also violated the NLRA. In its reasoning, it said that public statements about the workforce are central to an employee's exercise of rights under the NLRA. And again, the provision was very broad and prohibited the employees from making statements that in any way could be seen as harming or disparaging of the hospital. So let's go to the next slide. Now, after this decision came out in February, a lot of employers were sort of wondering, okay, where do we go from here? Can we have confidentiality provisions in our separation agreements? Can we have non-disparagement provisions in our separation agreements? So about a month later, the NLRB General Counsel issued a memorandum with guidance on the McLaren-McComb decision. And it did provide some guidance, but it also left us with even more questions. So first, the board's memorandum clarified that severance agreements are not banned. So you can still enter into severance agreements. You can still offer severance agreements to employees. But according to the General Counsel's guidance, employers should not offer severance agreements to employees that have overly broad provisions that would affect the rights of the employees to engage with one another to improve their law as employees. So basically, it's just reiterating what the board said in the McLaren-McComb decision, which is if the provisions in any way impact an employee's ability to exercise their Section 7 rights, then the board is going to find them, the board is going to find that they violate the NLRA. Now, one other interesting piece that came out of the General Counsel memorandum was that there's a statement in there about how severance agreements offered to supervisors could also be unlawful. Now, earlier I had mentioned that supervisors do not have Section 7 rights, and I went through, there's a test to determine whether or not an employee is a supervisor. So you were probably thinking, okay, well, we can give these agreements to supervisors because they don't have Section 7 rights. And the General Counsel memorandum says, hey, maybe not so fast. And the reasoning is if there's an overly broad confidentiality provision that could be interpreted as limiting the supervisor's ability to participate in an NLRB proceeding, then that would be unlawful under the board's guidance. Now, finally, there was one other thing in the memorandum that we wanted to point out, and it's that the guidance says that the McLaren-McComb decision will be applied retroactively. So what that means is if employers have entered into severance or separation agreements with employees in the past that have these overly broad confidentiality and non-disparagement provisions, then the board would take the position that those provisions are unlawful, even though they were entered into prior to the McLaren-McComb decision. Now, That's not necessarily a huge concern because there is a 6-month statute of limitations to file an unfair labor practice charge, which is what we're going to talk about at the end of the presentation. So there's really not much to worry about there. But Chris is going to take it over from here and talk about this decision and all the things that I just explained and how that impacts you practically when you're thinking about either a reduction in force or even just a single separation or severance agreement with your employees. So go ahead, Chris.
Okay, thanks, Molly. And Brooke, we can go to the next slide. So with respect to, takeaways, obviously we have the McLaren decision and we have the GC's memo, and you can tell that the NLRB is definitely going to be scrutinizing your agreements, your separation agreements, and as we'll discuss in a few minutes, many other types of agreements as well. So any agreement that arguably restricts employees' Section 7 rights under the NLRA will be heavily scrutinized. So general considerations and risk factors to take into consideration. So as Molly touched on, separation agreements with supervisory employees, generally there's no issue there. Supervisory employees are generally not covered by the Act. Molly touched on, the one potential carve out with respect to supervisors. If a supervisor is saying, I'm not going to give this overly broad separation agreement to my employee because it contains, confidentiality and non-disparagement, that is too broad. I guess under the NLRA they can't be retaliated against for doing that, and so that's another potential carve out. But generally you're fine to offer these agreements when you're making separation agreements with supervisory employees. Separation agreements with non-supervisory employees, you should use extreme caution in light of McLaren and in light of the GC's memo. And as Molly touched on, even with a non-union context, even if there's never been a union involved, there's no organizing going on, that type of thing, it's probably advisable to remove overbroad confidentiality and non-disparagement provisions. We'll talk about a few carve-outs that you can put into the agreement if you do want to include confidentiality and non-disparagement, but you still need to use extreme caution with separating employees in the non-union context. And then with respect to separating employees in the union context, non-supervisory employees, highly risky, and it's certainly advisable to remove confidentiality and non-disparagement provisions.
I'm sorry to jump in. Brooke, can you go to the next slide, to Chris's section? There we go, in the next one, thank you.
Oh, great, yeah, thank you. So the statute of limitations issue that Molly mentioned, it's untested. It's probably subject to appeal, and we'll see where it goes. The GC did say that employers should consider remedying past violations. So if you have a past agreement that's overly broad, the GC says you should reach out to those employees or past employees who are subject to the overly broad agreements and advise them that those provisions are void and that the employer will not seek to enforce them. Obviously, you need to, balance the risk of doing so and receiving a potential ULP charge. So, I think if you've done a RIF, reduction in force, in the past 6 months, it might be something to consider. If you've engaged in a RIF and have separation agreements that are older than 6 months, it would be a very conservative approach to do that, but it's something to consider. And note, while we're talking about the GC memo, even when an employee requests that an agreement include broad confidentiality and non-disparagement, which would probably be in limited circumstances, according to the GC, it would still be unlawful to include broad confidentiality and non-disparagement provisions because, the board protects rights that cannot be waived by employees. go to the next slide, Brooke, please, general considerations. So given what we've already discussed, I think, one of the important questions is, do we really need broad confidentiality and non-disparagement, or do we need confidentiality and non-disparagement at all? The GC's memo states that clauses that are narrowly tailored to restrict dissemination of proprietary or trade secret information for a period of time based on legitimate business justifications, that's lawful. So, it's not as if confidentiality clauses are entirely banned, but they are severely restricted, and any provision that precludes employees from, talking with each other about terms and conditions of employment, talking with the NLRA, the NLRB, and that type of thing will be heavily scrutinized. So the question becomes, is it necessary to protect the company's interests? Do we really need confidentiality and non-disparagement? Maybe in a large-scale RIF, or when an employee who is separating does not have access to confidential information or trade secrets, maybe those provisions would have little value. On the other hand, if we're talking about a different type of internal realignment, or there's sensitive issues involved, maybe it would be valuable to take a little more risk on and include these provisions. So it's really a case-by-case analysis. Be mindful, you'll see the last bullet point there references state and federal laws that might restrict the scope of confidentiality. Many states have laws that might restrict separation agreements in other ways. One example is the Federal Speak Out Act prohibits enforcement of non-disclosure and non-disparagement clauses when you're settling or in cases involving sexual harassment or sexual assault. So just be on the lookout for potential laws that might otherwise affect the agreement that you're entering into. Confidentiality clauses that prohibit disclosure of financial terms of an agreement will still likely be deemed lawful, even in light of McLaren. When you're when you're separating employees, confidential and non-disparagement provisions, confidentiality provisions that prohibit sharing the mere existence of the agreement will likely not be deemed lawful. Note also that, and the GC memo backs this up, non-disparagement provisions that are limited to employee statements about the employer that are defamatory are likely lawful. So you can keep these provisions, these non-disparagement provisions, with regard to maliciously untrue statements made with knowledge of their falsity or with reckless disregard for their truth or falsity. So defamation is not necessarily protected. Next slide, please. So it's important to review your existing templates to determine legal risk. And as I touched on a few minutes ago, while today's discussion is really focused on severance and separation agreements, the McLaren decision and the GC memo applies to other types of agreements as well. So it's important to review all types of templates, whether we're talking about settlement agreements, even offer letters, employment agreements, handbooks, that type of thing. I think all of these will be scrutinized. And so when you're reviewing the agreements, you're looking for terms that could potentially be construed as restricting Section 7 rights. And if an employee cannot lawfully be restricted, you'll want to consider the value of including the clause versus the risk of facing an unfair labor practice charge, which Molly will touch on a little bit more in a few minutes. And so if the terms could be interpreted as restricting Section 7 rights in your templates, those restrictions should be narrow and in accordance with the McLaren decision. And on the next slide, I'll talk about carve-outs and severability as well. Brooke, you can move to the next slide, please. So severability. So the board states, or the GC memo states, that the board will generally seek to void only those provisions it determines to be unlawful. instead of voiding the entire agreement. So if there's an overbroad confidentiality provision or an overbroad non-disparagement provision, that can be removed from the agreement if it's found to be unenforceable, and the rest of the agreement will be enforced. So it's important to use a template that provides exceptions to confidentiality provisions for speaking to investigators, participating in agency hearings, filing charges with federal agencies, et cetera. But you'll also want to include strong carve-out and severability language that, nothing in the agreement prevents employees from exercising Section 7 rights or filing a charge with the NLRB. So it's really important to include language, that any provision found to be unenforceable will be construed narrowly, and that the parties mutually agree, and oftentimes, especially if they're represented by counsel, this is given even more force. Parties mutually agree that the remainder of the agreement will be given full force and effect. So with that, I'll turn it back over to Molly to discuss the impact of continued use of broad confidentiality and non-disparagement agreements. And here, Molly, I'm supposed to remind you to read out the CLE code as well.
Great. Thanks so much, Chris. Okay. Can we go to the, yeah, there we go. Thanks, Brooke. So the CLE code is SS, like Seyfarth Shaw, 6414. So that's SS 6414. All right. So to close out the presentation, we want to talk about what the actual risk assessment is if you have included broad confidentiality or broad non-disparagement provisions in your separation agreements in the past and are planning to use them moving forward. So ultimately, we've hinted at this throughout the presentation, the real risk is that an employee files an unfair labor practice charge. And the risk involved there is obviously greater in a unionized workforce, obviously because those employees are represented by a union, they're more familiar with this process, the union is on the lookout for these types of issues. So if you're dealing with a bargaining unit, the risk is a lot higher. And then frankly, the risk is lower in a non-unionized environment for the same reasons. They don't have a union, they may not be aware of these issues, but the risk is still there because again, all employees, employees don't have to be in a union to have Section 7 rights. So the risk exists. And for those who may not be familiar with what that practice and that process entails, but if there is an unfair labor practice charge filed, it essentially kicks off an administrative proceeding with the NLRB. The board will investigate the ULP, and that involves getting evidence from the employee and also from the company in the form of a position statement typically. And then the board will determine whether to issue a formal complaint, which will then lead to an administrative hearing, which is essentially a mini trial before administrative law judges. So it is a process, but again, the risk depends on the type of workforce that you have and the types of employees that you're giving these separation agreements to. Also, if there were to be a ULP filed about a separation agreement that's been given to an employee or employees, really the remedy would probably be something like a rescission of the unlawful provision. So basically making the confidentiality and non-disparagement provisions, taking them out of the agreement and making them unenforceable. And then maybe posting a notice within the employer's workplace that it will cease and desist from including those types of provisions in severance agreements moving forward. Finally, I want to note that the McLaren-McComb decision is currently on appeal to the Fifth Circuit. So we don't know what courts will do in terms of whether this decision is going to be upheld, whether the Fifth Circuit will change course. We don't know what courts will think about this and what they'll do with these types of provisions. So we're sort of in a gray zone. The risk assessment is very dependent on the type of workforce that you have, but ultimately it's the risk of employees or an employee or employees filing an unfair labor practice charge. So that's all we have for our presentation today. I want to let you know that, as Chris mentioned at the beginning, we have 2 more webinars coming up in this series. The next one is going to be focused on WARN Act issues in RIFs, and then the final presentation will be on using AI and technology in reductions in force. So we hope you come to those webinars in the next few weeks. And thank you again so much for your time today.
Thank you.